everybody. Welcome. We're going to do things a little bit differently this evening. Our moderator is actually on Zoom. Kendra's here on Zoom with us, so we're going to try that and see. And I will pick it up if that doesn't work. I'm Kate Medeiros. I'm the co-president of SNSC. I'm going to introduce our panelists. Some of you will get my phone number from last time, and then we'll get moving. Let's see if I can do this one. Caitlin, a Waterbury native, began her work with Jim Caffrey in July of 2016. Caitlin graduated cum laude with a JD from Vermont Law School inaugural accelerated JD program and a magna cum laude with a BA from the University of New Hampshire. She's licensed to practice law in Vermont and New Hampshire. As with the rest of the Caffrey and Keating team, Caitlin strives to ensure clients are well informed about their options for their present and their plans for the future. She works closely with clients to prepare a comprehensive estate and or special needs plan that addresses the client's personal concerns and accurately reflects their wishes while providing peace of mind about their personal future and that of their family members. Alicia's practice focuses on trust and estate planning, special needs planning, and elder law. She is passionate about helping people plan for the future with clarity and confidence, ensuring their wishes are honored and what matters most to them is protected. Her approach is rooted in compassion and practical guidance tailored to each client's unique needs. Alicia earned her Bachelor of Arts in Psychology from Florida International University and a Juris Doctor from the Thomas F. Cooley School of Law. Before relocating to New Hampshire in 2021, she served as counsel for the New York City Department of Education's Special Education Unit, representing the district in legal matters related to the special education and the right to a free, appropriate public education. That experience continues to inform her work supporting families with loved ones who have unique or complex planning needs. Allison counsels clients on trust and estate planning matters. She's adept at simplifying the process, providing laser focus on important issues, and ensuring the plan operates efficiently based on her client's unique circumstances. She supports and guides families through the estate, probate, and trust administrative processes after the death of a loved one. In addition, she engages with her clients to accomplish their sophisticated estate planning needs, including the implementation of tax, charitable giving, asset protection, and wealth preservation strategies for high net worth individuals, families, and business owners. I'm going to do mine in the third person also because I can switch back and forth. Kate started her career in the financial services industry after a decade as a board-certified behavior analyst, working with children and adults with disabilities. In conjunction with her certified financial planner, CFP certification, her experience with families and the maintenance of her BCBA credentials provides Kate with a unique understanding of how complex needs within family systems drive decision-making. So that's a little bit about us. Kendra, I'm going to shoot it to you.
Great. I just want to get a sense of the room. Could you all give a thumbs up if you can hear me in the back?
Yes.
That's wonderful news, guys. So we're going to start with our first question for the panelists, and we will open time for questions for both those in person and those remote later on. So starting for families who are just beginning their estate planning, what are the first steps they should take to ensure their child's long-term security?
Sure, and I'll jump in on this one. And you guys, again, if I miss anything, let me know. So, when you're starting estate planning, there's kind of a suite of general estate planning documents that you're looking to put in place. The healthcare directive, which is more focused on you. You know, if you can't make your own healthcare decisions, who will make them for you? The power of attorney. That appoints an agent to help with your finances during your lifetime. If you are managing, for example, an account on behalf of your children, but if that is in your name and something happened to you and you needed somebody to step in, then your agent under your power of attorney could do that. So that's really important to have in place. The will is an important piece of the estate planning. We're going to talk a lot about trust today, but you will still, trust in some ways can take the place of a will. But you should still have a will. That is where you would name a guardian of a child. So that is a very important piece. And then I think we're going to be talking a lot about trust today. So trust, there are many different kinds of trusts. Where we usually start is what's called the revocable living trust. And this functions as a will substitute, a void probate court, which is something that's great to do as part of the estate planning process. So it doesn't necessarily have to do with your children or special needs loved one, but what that can do is it provides a lot of flexibility in how your loved ones can inherit from you. And you can, within that trust, and we'll talk about this in a second, but establish what's called special needs or supplemental needs trusts for your loved ones. So that is the basic suite of documents that you'll be looking to put into place if you go see an estate planning attorney. Is there anything else that you guys do regularly as part of that?
Like ancillary documents, if you do a trust, you're going to need a deed into trust or some form of a deed into trust. There are extras, but that's the basic, yeah.
I would say just to tie in from the last session, since this also says steps they should take to ensure their child's long-term security. Last session we talked about guardianship and powers of attorney, so I would right. So I would just say that if your child has capacity to sign and execute powers of attorney themselves, you might want to consider that too, while you're taking care of your own estate plan.
Sorry, before you guys go on, I just wanted to know, is this information like that you're telling us here verbally somewhere to be found? They point us towards somewhere where it's printed, where it's...
Well, I would say that just reach out to an attorney because they're going to be the ones that will direct you in what Allison just mentioned.
Great. This is just...
Just a reminder that when there's a question from in the room, the people on Zoom can't hear the question, so repeat the question, please.
So the question was, is there a place that we could direct them to find kind of the list of documents?
Yeah, I will probably multiple times tonight plug the Special Needs Alliance. That is a website you could check out for, you're not going to find will explanation at that site, but you are, it's a national group of attorneys who are doing special needs planning. It's invitation only, so these folks have been doing special needs planning for, that's all they do, and they've been doing it for a long time. And they publish a newsletter called The Voice. It's a free newsletter. It's on their website, and they cover all sorts of topics. These are my own copies, so I apologize I didn't bring enough for everybody, and if you at home, you won't get one either, but there are articles including how do I start my estate special needs plan, and then it is a 2-page document written by these professionals but written for individuals and their families, and it's just here's a summary bullet point, these are the things you should be thinking of. How is the special needs trust taxed, things like that. What should I put in place to prepare for my attorney before I make that phone call about my own will. So I do recommend, and I will multiple times, but the Special Needs Alliance website is another great place to start.
And just to talk a little bit more about the background about why you want to trust in the first place as opposed to just a will. I don't know if anybody here has had to deal with probate court before, but it's, you know, it happens every day, right? I've never had a client go through probate and be like, man, that was awesome, you know? So probate happens as an asset titling issue. So there are several different ways that assets are transferred at death, right? So the first common way is by joint ownership. If Kate and I own the house together jointly and something happens to me, Kate automatically, by operation of law, will own that whole house, right? There's nothing that needs to be done. So jointly held assets kind of are first tier. Something happens to one joint owner, the other will own that whole asset. The kind of next tier is beneficiary designations. So common ones are like IRAs or life insurance. Whoever is named as the beneficiary, if something happens to the account owner, just goes to the administrator and says, I'm the beneficiary, here's the death certificate, the benefits are paid out to that beneficiary. If you own an asset in your own individual name without a beneficiary designated, then if something happens to you, there is nowhere for that property to go, right? It's kind of stuck there in limbo. So that's when probate comes into play. So probate is you go to court to have a judge decide where that property will go. If you have a will, that is where your will comes into play. So there's a common, and I'm jumping to the end here, but there's a common misconception that wills avoid probate court. They don't. The wills is just the instruction that the judge reads once you're in probate court. And then if you don't do any estate planning at all, there's a statute in every state, which is basically the state's best guess as to where your property would have gone if you did do estate planning. So to your spouse, to your children, of course, all outright, and maybe that's not the best situation, right? So probate is expensive and it's time consuming. In both Vermont and New Hampshire, you're looking at, well, it depends on the county, but at least a year we find to get through the probate process. And there's a bunch of filings to make. So you've got your petition to open the estate. You have to inventory all the assets. There are creditor periods that have to expire. If you want to do anything with the property in probate, you have to ask the judge for permission. And as you can imagine, the court fees pile up, and the time for if you hire an attorney, that piles up. So people like to avoid probate court if they can. And one common way to do that is the revocable living trust that I talked about. A trust is a separate entity that can own your property during your lifetime. So if it was the Allison Sherman Trust, I would then, and Caitlin mentioned this briefly, is transfer your property into your trust so that the trust is the owner. So if I have a house and my trust is the owner of the house, trusts can't die unless we tell them to, right? So if I put my house, I put all my property into my trust and something happens to me, my trust is still the owner of record of all of those assets. And then what the trust itself says is who steps into successor roles to manage that property. So who is going to be the next trustee, the next manager of the property for the benefit of the next beneficiaries. And that process can happen automatically. Well, really next day, there's a little bit of paperwork to be done, but nothing like probate court. And you can take over the management of that. The next trustee will do what the trust says to do, and that's what we're going to be talking about, is what the trust can do for you. And then once everything has been dealt with, everything has been administered, the trust will shut down of its own accord. So you're able to kind of get your assets to your beneficiaries without having to go through that probate court process. So that's the general overview of what the trust kind of does in the background. And then I think we'll talk more about how it can be tailored to really help, we're going to avoid probate, and we're going to make sure that your assets are distributed the way that is the best for your beneficiaries. So
I think as the only non-attorney up here, what we see with our clients who we advise to go see an attorney is, well, I don't have enough assets for that. And the reality is a trust doesn't need a lot of assets. You need to protect the assets that you are hoping to pass on to the correct beneficiaries, but it doesn't need to be $1 billion. It needs to be your house or whatever.
Probate happens no matter what the value is, right? In Vermont, there's a simplified probate process if you have less than $40,000, but you're still going through probate, right? So, and is there a de minimis in New Hampshire? 100? I think it's 25,000. So we're not, we're talking about maybe a beat up car can maybe do a simplified probate. And it's just, so that's right. It's not the value, it's the titling that is what matters.
Just an example of that also, clients had attempted to avoid probate and did a great job with almost everything, and there was one asset that paid out by check. It was maybe $3,000, and of course it cost more than $3,000 to get that through probate and ultimately delivered to the beneficiary. So it can be, it doesn't matter, like you said, it doesn't matter how small the asset is.
If you do get a $3,000 check, we might say, oh, that's too bad. Forget about it. It's going to be a little harder to get it done, and it's a lot more expensive to get it than to just let it go. Yeah.
We have a question from Evan online. Evan, go ahead.
The last two people are a little garbled for those of us that are online. Allison, we can hear, but when the other two people respond, it's a little garbled. I maybe the placement of your microphone.
Yeah, we're going to adjust them a little bit and you can tell us when it's better.
Are these microphones connected to
The
the,
other two are on the left. Thank you.
wait, are these microphones connected to the computer?
They're connected to this.
Okay, so moving this closer won't help.
Oh, that's true.
Okay.
Right, that doesn't do any good.
Well, moving the computer towards the middle probably help, right?
I'll be a lot louder, right?
No, it's not Allison, we can hear you. It's the other two women that come across garbled on the Zoom.
How about now?
Can you hear us now? And can you hear me now?
Not very, you're harder to hear.
It's real. Thank you.
Any better? Any better?
Yes, thank you.
Okay.
Let's get there.
I'm wondering if there were any other questions before I move on to my next question.
Could I ask a quick one?
Yeah, go for it.
I know that you're going to cover a lot of the trusts. We actually have a trust, but I'm wondering when you acquire new assets, does that have to be updated in that trust? So we bought my father-in-law out of his part of property that was owned by my husband and his dad. Do we have to now update that will, that trust, to reflect that, or is it just automatically known that all of our assets, you mentioned the $3,000 check, so do we have to go and have this redone again?
So the question for online is, if you have new assets come in after you created your trust, what do you need to do to make sure they're in your trust?
And so you do not need to necessarily redo the trust, but you do need to make sure the asset is titled in the name of the trust. So the deed for that property, how is that titled?
In our meetings.
So we got to check together. So that's not in your trust yet, but all you have to do is a quick claim deed or it's a one pager from you individually into your trust.
Okay.
And
So the trust is the King Family Trust. So that's what the deed to our home needs to say is the
That's right.
King Family.
yeah.
Oh my gosh.
And you can still, if whatever's in your trust, if it's a revocable living trust, which is kind of, again, the first stepping stone, you can add and remove property from that at any time. So just because of you put your house in the trust, you can still sell it. So it doesn't go away or you don't lose access to it. So that's important to know too. So yes.
So how do you do that with vehicles though? Because when you go and you finance a vehicle, I'm not going to finance it in the King Family Trust.
Why not?
Oh, really?
Leasing?
Okay.
No.
Well, but, yeah, if you own it, the trust should own it.
As well as bank accounts as well.
Yep.
Okay.
If you want to avoid probate.
Right.
Yeah, no, we want to avoid probate.
You mentioned a common misconception and something that we'll kind of summarize with at the end, but I feel like we will mention those throughout this. A common misconception is, I went to my attorney, I prepared my revocable trust, and I'm done. I did it.
Yeah.
And everything that I could own is now owned by my trust. That's a misconception. The trust document is a piece of paper and that's it. It creates an empty bucket and you need to make sure all of your asset spigots point into that bucket. Whether you retitle assets by purchasing them in the name of the trust while you're alive or designate the trust as beneficiary so that it passes directly to your trust when you die. But every asset you own has its own spigot and you need to make sure it feeds into that bucket, if that's your goal.
Okay.
And the nice thing about the will is, so, and we're going to, again, talk in a minute about what you can have to build out your trust say to help with your beneficiaries. You'll still have a will, which you will not need if we avoid probate court. But it happened in my family. My grandfather had a trust. He had a lot of land up in Belvedere, Vermont. Special points if you know where that is. It's in the middle of nowhere. He transferred all of it to his trust, but he forgot one acre parcel that had been subdivided like 40 years prior. So we ended up having to go to probate for that one acre parcel. What your will say is if something is forgotten, if you have bought something later or there's a bank account that's forgotten, please put it into your trust. So it's called a pour over will. It makes sure that if at the end of the day something is forgotten, it will end up in your trust. Now, did we avoid probate? No, but still everything is going into the trust the way that, and then will be distributed the way that will protect your beneficiaries. So I'm sure that you have that as part of your plan too.
So, and my firm, as part of helping to fund the trust, as a part of a complete estate plan, when you do a revocable trust, we do give you homework. We help with the deed preparation as well as my counterparts here also do that. But we help with the deed preparation, moving the house to the trust, you're signing the deed. So at the end of the day, once you sign all the paperwork, your house will be in the trust, will be funded in the trust. We also provide what we call bank instruction letters. Unfortunately, we can't go to the bank and move your accounts into your trust. So we give you those letters along with what's called a certification of trust. So that, and a very detailed letter that says to you, this is your homework to do. If you own cars outright, go down to your, wherever you usually register and retitle, go down to that office, provide them with the documentation so that they can move the cars into the trust. You go to the banks and you move your checking accounts and your savings accounts and your CODs into the trust, or CDs into the trust. And so we're helping you. We provide a very detailed letter that says what your homework is, and we also give you some funding documents to help with that as well.
Can I add a Vermont specific thing too? Can I get a read on how many Vermonters are in the room? Okay. And I don't know if there's like a hand raise function for online, but Vermont DMV has to transfer. Okay, we got some Vermonters. Vermont DMV has a transfer on death form that you can fill out, and you can designate your revocable living trust as beneficiary of a vehicle. The form is limited in that it requires only one owner is allowed to transfer to a trust. Unfortunately, it's just a limitation of the form, but that's a transfer on death form at the DMV. Does New Hampshire have something similar? No. And then Vermont is also one of a small handful of states that essentially has a transfer on death deed. It's a special kind of deed that it preserves your home from Medicaid recovery twice. When you're getting older and you yourself need long-term care Medicaid, the way you qualify for that is also being financially eligible. You cannot have a lot of assets and qualify for Vermont Medicaid. Your house is an exempt asset. Again, there are limits, but in general, your house is exempt if it is your primary residence in your own name. So if your house is owned by your revocable trust, you lose that exemption. You want to keep it in your own name, and you can in Vermont, and then have that, this is not the legal term, but it's a transfer on death deed that will transfer your home to that revocable trust immediately upon your death. And so skip probate, where Medicaid is a creditor. So you skip that, and it goes straight into your trust as soon as you die. So that's a benefit of being a Vermonter. I think there are lots, but that's a couple of them.
New Hampshire just passed well, you can designate a beneficiary of a house in New Hampshire now. So, although I haven't seen it work out much.
Right.
That's no, it just passed last year. So.
Yeah, and you would be able to do it in New Hampshire. If you're a single individual and you're not living in your house anymore, you wouldn't be able to use that transfer of death deed.
Yeah. So we see an attorney.
Yeah.
Go ahead.
Are there any other questions before I ask my next question?
Not from the audience.
Okay. Then thank you for that. Let's go into a particular type of trust, a special needs trust. There's first party and third party special needs trust. Can you explain the difference between them and when each might be appropriate?
I'll start with a first party special needs trust. First party and third party refer to whose money it is. So first party special needs trust is first party money, the disabled individuals own money. First party special needs trusts are for legally disabled individuals. It's a pretty high threshold to even qualify. You have to be legally disabled. You also have to be under the age of 65 to establish and fund a first party special needs trust. But it's a way for you yourself to save some of your own assets in an exempt trust and still qualify for means tested benefits. When I say means tested, I mean benefits like Medicaid and supplemental security income that only are distributed to you when your income is low and or your resources are low. You might be familiar if you're on supplemental security income and the Medicaid that goes with it, you cannot have more than $2,000 in your own bank account, the disabled individual's own bank account. So if I'm a disabled individual and I earn just enough that by the end of the month I have more than $2,000 in my bank account, or if I purchase a winning lottery ticket, or if I get bumped crossing the street and I have a personal injury settlement, or if mom and dad did not do advanced planning and they died and I got their assets, all of those are examples of scenarios where me, the disabled individual receiving supplemental security income and Medicaid, I'm facing ineligibility for my benefits. They're going to say, awesome, you just got that money, spend that money before Medicaid dollars kick back in. I can transfer the excess money, everything over $2,000, into a first party special needs trust. And then my benefits will continue. Money or assets in a first party special needs trust are exempt. They're not counted by Medicaid and the Social Security Administration when they're determining eligibility for supplemental security income and Medicaid. It's restricted, the use is restricted to, that's referred to as the sole benefit rule. That money can only benefit me ever. If I have kids, can't benefit them. If I want to go to a friend's birthday party with a present, I can't use that money to buy that birthday present. The money from a first party special needs trust has to solely benefit me, and it's a requirement that upon my death, Medicaid gets first dibs at every dollar left in that trust. So that's Medicaid's condition for saying, we see that you have this money, and we're going to let you put it over here in this first party special needs trust and continue your benefits, but when you die, we get that money back, or whatever's left, for every dollar that we have paid into your care over the course of your lifetime. That's a first party special needs trust. I'll note, and we'll get to ABLE accounts later, first party special needs trusts are not the only tool for the disabled individual's excess money, but it is a tool, and it's a great tool for many people.
Is there a maximum like there is for the ABLE?
Great question. The question is, is there a maximum contribution limit to a first party special needs trust? Because there is for an ABLE account. No.
Okay.
There is no contribution limit. There's no maximum you're allowed to have. There's no limit to the amount of money that can be held in and administered from a first party special needs trust.
How educated are the people that work at Vermont Healthcare about those kinds of stuff? Because my brother was moving up and delivered me. I inquired with them about getting Medicaid, saying, he had like a 401k company he worked for 30 years, which held $8,000. I was instructed that I had to spend that down. I asked if there was a special trust or anything that could be put in, and he said no.
So the question is whether Vermont Medicaid, the folks that answer the phone when you call Vermont Medicaid are aware of first party special needs trusts and aware to share the information about special needs trusts with folks who are calling. And the person asking the question also mentioned that the issue you ran into related to a 401k. Retirement plans are treated differently. It doesn't mean they cannot be owned by a first party special needs trust, but they are treated differently. So that might be why Vermont Medicaid told you should spend that down. Again, the person also mentioned it was $8,000. So your brother's $8,000. I probably would have recommended he spend that down too. You're going to spend a few $1,000s to establish a special needs trust, or just spend, I mean, I could spend $8,000 pretty quickly. I know that not everyone can, but I would recommend that you do just that. Really look at what he needs. Is there a debt he could pay down? Does he need winter tires? Those are expensive as heck. I would still recommend looking at other options. And then there are two other options that I would consider for your brother's $8,000 before I would recommend a first-party special needs trust. So again, a first-party special needs trust is a tool, but it's not the tool for an individual's own assets. And I will say for our office, whenever we're preparing a special needs trust for clients, regardless of whether it is funded today or funded 50 years from now upon mom and dad's death, we submit a copy of that special needs trust to Vermont Medicaid and to Social Security, whichever benefits the person is receiving, with an explanation letter expressly saying exactly what the trust is, exactly which code it fits into, exactly which rules it is allowed under. I can't say what the agencies do with it once we put it in the mail, but they get a cover letter from us that explains exactly what that trust is, and it's on their files as soon as we establish a trust
The
with
folks at Community Bridges who have been taking care of it suggested that I could put it into some kind of a trust that was possible in New Hampshire, and it was also possible in Vermont. And that was kind of all we had. And I just thought, what if we needed something down the road? So it would have been beneficial to put it in an account like that for him. It was also nice that he could spend it down. And then he hadn't had cancer in the past, and I thought, let him treat himself and get things that he needed, and which he did.
The comment is just continuing what to do with that $8,000. We'll talk more about ABLE accounts, right? Pay attention that, I think, yeah, because that's another great tool for smaller amounts of money that are bumping stuff off their benefits.
Are there other questions about first-party special needs trust, or should we move to third-party special needs trust? Third-party debt. What's that?
Oh, I'm sorry. I missed the question too. Whether we're doing ABLE now?
Yeah. Do you want me to do? Sure. Third party. Okay, so third party special needs trust. Like you said, depends on who's creating the trust, right? So a third party special needs trust is created by somebody else on behalf of the disabled individual. Usually parents, although it doesn't necessarily have to be parents. That it can be incorporated into the revocable living trust that we were talking about, or set aside as a separate entity. Either is fine. Usually what we do is as part of your revocable living trust. Let's say you have 4 kids, one is receiving federal benefits, so your revocable living trust can take care of all of the kids, and then we'll have a sub-trust within that we call the special needs or supplemental needs trust. If you are a third party setting up a trust for a disabled individual, you have a lot of flexibility, a lot of freedom. Basically, what the trust will say is that the trust funds can be used for the benefit of the beneficiary for really whatever they need, except for what they are receiving federal benefits for. So if their housing is provided, their food is provided, it can be anything else. It can be vacations. It can be, oh goodness, now it's all going blank in my mind. But there's a whole list a phone,
iPad,
TV, whatever is not already being paid for. So the trust says specifically, if you are getting federal benefits for specific purposes, those are completely disallowed. And because it is disallowed, that fund can't be used for that, right? They need so the federal benefits will continue, or the benefits will continue. The nice thing too is it's not subject to Medicaid recapture, but just double checking. No, it's not subject to Medicaid recapture, and you can designate where it will go if the disabled individual dies, like to their children, to your other children, to charity, to really anybody you choose. And that trust would stay intact for that beneficiary's lifetime.
And then really, I will say, just practice difference. We never prepare some special needs trusts in a revocable trust. One of the reasons is, again, we're giving a copy of the trust to Medicaid and Social Security. They have to review the whole trust. So why give them your whole entire family personal revocable living trust if they don't need it? And then to the other audience members' point about folks understanding, we do see a lot of issues with, for example, a Medicaid or Social Security officer being confused by a revocable living trust. Well, it's all these other terms, and it's called this, and it's not called a special needs trust. It's called mom and dad's revocable trust, and we have to do a lot more explaining. Those are just a couple reasons why, just a practice difference. It's not incorrect to do either, but we always do prepare a standalone, separate, special third-party special needs trust for folks.
Well, I would say that I've done third-party sub-trusts within a joint revocable trust. I've also done standalone third-party special needs trusts, and I've also done what's called a testamentary special needs trust, where if someone doesn't want to avoid probate, they want to go through the probate process, but they still want to have a special needs trust. They specifically write in their last will and testament that they're leaving money to a third-party special needs trust, but it's called testamentary because now it goes through probate. And I would say with the testamentary special needs trust, the probate court is involved beginning to end. And then reasons why I would put a sub-trust within a joint revocable trust. Typically, I look at what the client's funds are, what they can afford, because a standalone third-party special needs trust to draft that is a little bit more expensive than putting a sub-trust within a joint revocable trust. And then I've also done discretion to the trustee to then create the third-party special needs trust upon the second or first death, which they would then create the standalone special needs trust upon death. So there are different instances, and I just look at what funds my client has and direct them in terms of maybe which option might be best for them, and then let them decide. But of course, the con with having a sub-trust within a joint revocable trust is that once it does go to the Department of Health and Human Services or to the Social Security Administration, they're taking a look at this joint revocable trust that's your trust and not really peeling it back to see the sub-trust that's within it. So you're giving them all of the information up front. So pro is having a third-party standalone special needs trust that the Department of Health and Human Services is just looking at that special needs individual third-party special needs trust and not your full joint revocable trust with a third-party sub-trust within it. That's a lot of
Are there questions about special needs trust, or should we start comparing special needs trust to able accounts? Questions in the room or on people?
No question. Can I add a couple? Are you able to see remote questions?
If I am able to see if someone has their hand up.
Okay. Just a couple quick notes based on a couple things that the two of you said. That catch-all, if someone is disabled at the time of my death who is a beneficiary of my will or a beneficiary of my revocable trust, your will and or your trust can and should have like a catch-all provision in it that says, just in case someone is disabled, I give my executor or my trustee authority to create a third-party special needs trust. That way you don't create problems for someone who becomes disabled before you die. Any of us can become disabled, and we aren't today, but we might be by the time the person creating these documents dies. So every document can and should have that catch-all just in case provision.
So that'd be a question to ask the lawyer you're working with, like, does your form document have this within it? Because it should.
Yep. And then another comment regarding what the special needs trust is used for. Again, it's used for everything that your benefits aren't already covering. However, it should never and doesn't need to be so restrictive that it doesn't allow your trustee to spend on things that your benefits already cover. And a classic example is housing. Supplemental security income is for housing, and you get a deduction if you have any other funding source, a special needs trust, mom or dad, anybody else helping you pay for housing. So in a lot of documents or some people's third-party special needs trust, it's accidentally too restrictive because it says the trustee may never spend on things that the benefits are already paying for. It can, and in a lot of cases it should, because if that, dingy apartment in a bad neighborhood is what is being afforded by that supplemental security income, but the special needs trust has money and sustainability to pay for this much nicer place over here that's safer and in walking distance to the person's work, then get rid of some of those supplemental security benefits and pay for that better housing. So that's another thing your trust can do. Like you said, it's flexible.
Yeah. Trustee discretion is what we call it.
Yeah. Yes.
So then who are the typical trustees of third-party special needs trusts?
Good question.
Who are the typical trustees of a first party or third party special needs trust?
Yeah, especially third party.
Especially third party.
I'll give you the best lawyer answer ever. It depends. Oh my goodness, it completely depends on your situation. So, in a lot of cases, it could be another family member. In some cases, it's better to have an institution. I usually see family members. What about you guys?
Yeah, I typically see family members. So what I see is if they're doing a joint revocable trust and they're doing a standalone third-party special needs trust, I typically see it's the same family members that they named in their joint revocable trust as successor trustees. They're naming the same individuals in their third-party special needs trust as well. When I'm discussing successor trustees with my clients, though, I'm letting them know that that person should have knowledge about the individual with special needs, the specific plans or programs or benefits that they're on, because it's a delicate dance. It's, can I make a distribution for this reason? Will that cut off eligibility for this benefit? So that person should be very knowledgeable when it comes to the distribution that can be made from first and third party special needs trust. Now, at the point in time where they do step in to manage and administer the trust, they're usually up to speed on that, and they can reach out to the benefits agency or to the special needs attorney for some more direction when it comes to that as well.
You can always ask for help, but it's one of the most important decisions to make as part of this process.
There is a short list of professional trustees in Vermont, at least, that we do provide to folks. It is short, it's a small state, but they are good professional trustees who work with families, and a lot of families, either because, again, classic example, mom and dad doing this planning for their child with disabilities, maybe they don't have another child who can serve in that role as trustee. Or maybe the disabled beneficiary is, for lack of a better word, so difficult to deal with that they don't want to put their other child in that situation. That might cause more conflict. Let them just be siblings and don't have this fiduciary role between them. Because on top of the special skills that they need to have, knowing the benefits and knowing what distributions do and don't impact benefits, that's on top of just being a fiduciary. They have to manage money for someone. So it really is, it's a job, and you've got to have a skill set. There are certainly plenty of clients who maybe named a family member against my recommendation, but that's your choice to make, who you name as trustee. In general, that's your choice to make. First party special needs trusts, if you have to go through a court, most of the courts I'm working with are not approving of parents or family members being named as trustee of a first party special needs trust, FYI. The courts don't like it.
And so what happens if something happens to your trustee? So I'm
significantly older, an older parent. I'm setting up a trust for my child, and I name my cousin, and he's significantly younger than I am, but older than my child. What happens if he also dies?
The question is, what happens if a trustee cannot serve because they died or any other reason? What happens if a trustee can't serve as trustee of a trust?
So in my trust, I typically build in language that if there's no successor trustee named within the document, that the acting trustee right now can appoint someone to step in after that. So whether that be an individual or a corporate trustee, that last acting trustee can appoint or nominate the next person after that.
And a trust will never fail for lack of a trustee. So if all of the trustees named in the document died on the same charter cruise, then the trust is not going to fail, but that's probably what a probate court would need to appoint someone or some entity to serve as trustee of a trust.
That's the last line, is the corrections.
So similar to that kind of a branch off, for us, we are also older parents. And although our boys are 19, their younger sister is 8. So our trustee would be the person that would obviously take custody of her. Is there a way to do it so that when she becomes of age and she could step into that trustee position, that it's transferred to her, or does that designated trustee actually have to die first?
We do that all the time. So if the question is, if you have, for example, siblings, children who are, let's just say under 25 or a younger age right now, but you think when they turn 25 or 35, that might be a good time for them to step into the role. We are often writing into the document, mom and dad are the trustee of this trust while they're alive. And then next is mom and dad's sibling until this other child of mine turns 25 or turns 30, and then they become trustee at that time. So there's no change in the document. You don't need to go back to a lawyer. It's just automatic. When that person reaches the chosen age, they can step into the role of trustee.
And that's typically what clause that says if they agree. That's have to agree.
Yeah,
because depending that sibling.
The question is, can you should you require that the trustee has to agree? Yes. Just because you're named as an agent or trustee or executor in any document, you can always decline the role. Always. Yeah.
What costs are associated with a professional trust?
What costs are associated with a professional trustee is the question.
So that depends on the corporate trustee. So when I have clients that come in and they're looking at a corporate trustee, or they're doing their interviews with corporate trustees, asking that corporate trustee, whether it's Cambridge Trust or in New Hampshire, it's Enhanced Life Options Group, it could be Plan of Massachusetts or Rhode Island, asking them for their fee sheet on what they charge. It's usually, sometimes it's a percentage of what's going into the trust. That's typically what I've seen, but it's asking them what that percentage would be.
Does anyone remotely have any questions? Go ahead, Jim.
I was curious about the comment that courts don't like trusts or don't like parents be the trustee of their child's first person trust. Is that what I heard?
Sometimes, without getting too far into the weeds, sometimes you have to go through the probate court to get a first party special needs trust established for a disabled individual. And you have to submit a draft of the trust to the court for approval. And the Vermont courts that I've been working with in general don't like to see family members named as trustee of a disabled individual's trust. They would rather see a corporate entity or nonprofit or some professional entity serving as trustee. And they are, remind yourselves when you're going through guardianship, when you're going through all of this, that the judge has the worst case scenario in their mind when they're making decisions. and they go from there. So worst case scenario is mom and dad were appointed as trustee of their disabled child's first party special needs trust, and they breached fiduciary duty, broke the law, and spent all the money. It's gone. They might go to jail, but the money's gone. And so that's what the court is seeing and has seen when they're making decisions like that.
Is there anything that would preclude doing both a first and a third party trust?
The question is there anything that would preclude having a first party special needs trust and a third party special needs trust? No, not at all. Lots of folks have both. Again, third party is for third party's money. First party is for first person money.
There's so many hidden gotchas in this area. I wanted to just make sure to ask.
Yeah.
I have a question. What do you recommend for someone with a disability that isn't on Social Security or isn't, someone say with a learning disability and they haven't applied for Social Security disability or Medicaid? I mean, do you recommend certain tests for that? Somebody that needs some help but maybe would qualify but hasn't applied.
So the question is, I'm going to rephrase your question.
Thank you.
Can someone who is not receiving means-tested benefits still be a beneficiary of a special needs trust? They cannot be a beneficiary of a first-party special needs trust unless they are legally disabled. Legally disabled, that's a term of art. But absolutely, they can be a beneficiary of a third-party special needs trust. A lot of, again, example is parents, but a lot of parents are saying, my child doesn't have benefits, they're working a full-time job, but they should not be in charge of whatever inheritance I'm going to give them. It's special needs trust, supplemental needs trust, discretionary trust, those are all the same thing, and it just means the trustee has discretion to make distributions for the beneficiary. And you do not need to be disabled or receiving benefits to be a beneficiary of a third-party special needs trust.
And what makes somebody legally disabled?
What makes somebody legally disabled is the question.
Right. It's a definition by the Social Security Administration's office.
So you have to apply.
Right. You have to apply, and it's based on how much you can work. Lots of people are disabled. A whole lot less are legally disabled, and it's literally just how much can you work. If you can earn more than X dollars, you might be profoundly disabled, but you're not legally disabled because you can work and earn. It's called substantial gainful activity. And I think it's 16 to 25. Yeah, it's very hard for folks who can work a full-time job, but otherwise cannot manage any other part of their life. There's a very fine line.
There's a whole assessment process, correct?
Yeah.
And my brother had to go through that when he came up here. And we tried to get him services. The assessment was quite lengthy and detailed. They tried to say because he'd just gone through chemo that he had chemo brain because of the memory issues. But I had a document from the doctor right up from when he was in his early 20s that stated all the issues and problems. And that was what was beneficial enough to allow him to get his services, but then he lost it again. That's why I'm here. I'm trying to find out, figure it out. Getting his services that he's supposed to have.
Well, I have a question, and I have a question for Caitlin. You mentioned if a first party, that the courts are disapproving of parents as trustees of first party special needs trusts. Is there a trust protector statute in Vermont? And how do they look at that?
Yeah, great question. The role of trust protector is another option for that sibling or for that other human person who has direct contact with the beneficiary, but maybe shouldn't be in that fiduciary role of trustee. And so the trust protector has oversight of the trustee's administration of the trust. They can review everything the trustee is doing. They can fire the trustee if they're doing a bad job, and they can appoint a new one for the trust if they think someone else would do better. You can also set a limit, so the trustee, for example, cannot spend from the trust on anything more than $5,000 without checking with the trust protector first. You can put in restrictions like that. The trust protector role is like a middleman or a liaison between the beneficiary and the professional trustee. And it can help with communication, especially if the beneficiary is challenging to communicate with. It can preserve family relationships because the sibling, for example, can say, I'm not the one saying no, it's the trustee, I'm just, don't shoot the messenger kind of thing. And then with first party special needs trust, generally, no, we're not. The court doesn't necessarily like the trust better if the parents are named as trust protectors with a professional entity served as trustee. When a court has no reason to not have parents serving as trustee, they are, the unicorn parents, they can manage money, they know all the benefits, there's no reason to say no to appointing mom and dad as trustee. Some counties in Vermont are still saying, I'll let the family member be trustee, but now the trust needs court oversight, and now I get to watch what that family member is doing. That's more the example of where a court is saying a family member is okay, but only if I get to watch what they're doing. And otherwise, trusts don't need to be in court. You can establish it in court, and then they don't have to ever see it again. But that's one way around that for courts. We'll let the family member be trustee, but we get to watch what they're doing.
So in our case, we have the trust, so obviously we've got that person that will be trustee. There's a clause that states our youngest that no money can be dispersed without that person until she turns 21 years of age. Can the person who right now is our trustee become that trust protector when she becomes 21 and steps into the trust?
Oh, your joint trust?
Right. Can they reverse roles once? So ultimately it's protecting financially so our two older boys can't have anything until she's 21 unless the trust controller is giving it to them. Can that role be reversed so that they become the trust protector when she steps into the
So the question is, the person you name as trustee while the beneficiaries are young, when one of those siblings gets older and is old enough to then be trustee, can the original trustee step into the role of trust protector?
Right.
Can I reiterate your question correctly?
To preserve the relationships even.
I don't typically see trust protectors for clients' joint revocable trusts, but if it was a special needs trust, certainly the roles could be reversed. And when somebody's acting as trustee, they can act as trust protector. So if your daughter was acting as trustee, then the person who's acting as trustee steps down, they could step into the role as trust protector.
You can imagine there's a billion different ways that this can all be drafted, and most we can do, but you just need to talk to an attorney.
I love Emily to ask a question, and then I want to make sure we move on to Abel if that's too.
Yeah.
Go ahead, Emily.
Thank you. I'm curious about bonds. So in one interaction with the courts on behalf of my son, it was through guardianship and conservatorship, but they had me certified to a bond. I'm wondering if the courts ever do that in the case of the primary special needs trust, where they say, okay, family member, you can be in that trustee role, but you need to put up a bond so that we know, we can come after you if you run off with your money.
Good question. Yeah, I've never had a court even consider that.
It's always in the discretion of the court, so it can always happen. How often does it happen? In Vermont, I hardly ever see it. New Hampshire is regular probate and need it every time.
Right, for probate or guardianship, I haven't seen it in a court in my observations. Right.
Yeah, it does depend, but the judges can always order a bond, so that's what you get.
Can you explain the bond? What's that involved?
So briefly, what a bond is if there's $1 million in the trust, it's you as the fiduciary certify that you are not going to run away with the $1 million, and you get a company to guarantee that. So it's like, it's like a insurance.
And you purchase the insurance policy.
So if you do run away,
There's a fee for the bond, it's a fee based on the monies that are being.
yeah, there's a credit check. It's a whole. Yep. Thank you. Yes.
Usually mine didn't involve a credit check, but I just had to certify that I would pay $10,000 or something. I don't know.
Yeah, it's a so there's surety bonds and non-surety bonds.
Yeah, that's based on just the amount of the probate estate or guardianship.
Yeah, it sounds like it's more relevant for the conservatorships than the trusts.
Right.
Yes.
Okay.
Thanks.
All right, we've got one question here, and then we'll move on to able accounts.
So for special needs trusts that are set up for somebody who our best guess at this time, this child will not have capacity to manage their own finances. But at the same time, they're still developing, and maybe when they're 25 or 28 or 30, you never know. They surprise you. Do you see either a trust set up in a way that can determine capacity at a later date, where the trustee can be the person's own, trustee of their own trust, or?
The question is whether a special needs trust can terminate early if the beneficiary doesn't need it anymore, and is not legally disabled and managing their executive functions on their own. They don't need the trust for benefits eligibility or otherwise.
Right.
Yes. Yep. That's usually built in, like that trapdoor we talked about. If it's the trust is revocable, so you can always change it. So yes, there's a lot of flexibility built in.
A lot of our third-party special needs trusts are irrevocable for other reasons, but either way, yes, especially it's pretty rare, but it's absolutely, you can write it in that says, when the beneficiary turns 50, the trustee can make an assessment at that time as to whether this is even necessary. You can also have the beneficiary, him or herself, write it in so that it's their decision to approach the trustee. Ultimately, it's the trustee's discretion, but it would give them a choice to say, I'm ready to take this money outright, free of trust. You cannot do that with the first-party special needs trust. If you terminate a first-party special needs trust early, Medicaid payback is triggered, even if the person is alive.
But I would also add to that, that the beneficiary, if they were to keep that trust, can never step into the trustee role. There are spendthrift provisions that are in place so that the funds that are in the special needs trust are not considered funds of the beneficiary. So it's protecting that. So they can never step into the role of trustee, even if they had capacity.
Thank you, everyone. I think that we have some more questions about special needs trust, but I would love to bring able accounts into the conversation because I think there's going to be some comparison between special needs trust and able accounts, and maybe that can help our questions a little bit. So can you explain able accounts and then compare them to special needs trusts, in particular around flexibility and protection?
All right, so able accounts are, I would say, they work in conjunction with first-party and third-party special needs trusts. So we have some handouts at the front. They're about 3 pages. It gives you a comparison between an able account, a third-party special needs trust, and a first-party self-settled special needs trust. So the chart goes into type of assets that are allowed. So within an able account, it's only cash. Self-settled special needs trust and third-party special needs trust, they can own cash, bank accounts. They can also own real estate and vehicles. Persons that can establish an able account would be the individual themselves, their guardian, an agent under a financial power of attorney, parent, grandparent, or even a representative payee. Individual must have been right now at least under age of 26 or under at the time, disabled at the age of 26 or under in order to start a ABLE account. That age is going up in January to the age of 46, so that's a win for individuals who have special needs who have been disabled before providing the age of 46.
And that was from advocacy from the Special Needs Alliance. Told you I would plug it again.
And then who can contribute assets to an ABLE account? Anyone can contribute assets to an ABLE account, including that individual. Their funds, if they're working, they can have their funds in the ABLE account. However, there is a maximum annual contribution, which is tied to the gift tax exclusion rule, which for 2025 is $19,000, and I believe for next year it's the same. It doesn't go up. With the self-settled special needs trust or first party and the third party special needs trust, first party, Caitlin said, only that individual's funds can go into that first party self-settled special needs trust. With the third party, anyone can contribute to the third party special needs trust. It's yours, the person's friends, that other family members can point to that third party special needs trust. Let's see, who owns and controls the assets after an ABLE account is established? Well, again, it's that individual with special needs, it's their account. So they're the one that's opening that account in their name. Of course, again, they have to have been disabled before the age of 26. And then the trustee for self-settled special needs trust is the one that owns and controls and manages the funds and the assets that are in the self-settled special needs trust. And similarly, for the third party special needs trust, it's that trustee again. So an ABLE account, the individual with special needs, they can only have one ABLE account that's going to be considered their own, that the Department of Health and Human Services and the Social Security Administration will consider not theirs. It's not a countable asset, or they're in terms of countable resources, countable income to them. Let's see, overall contributions. Said $19,000 per year. If the individual is receiving supplemental security income, the overall amount that account can hold is $100,000. Anything above that is going to be considered a countable resource to them. And for someone who's on Medicaid, the amount, that maximum amount that can be in that ABLE account is tied to a 529 plan, which is $596,925 in New Hampshire. If someone is working, we mentioned that substantial gainful activity per month, that's $1,620 that an individual who's considered disabled can earn and still be within that definition of being disabled. But they can contribute $15,560 to an ABLE account. So if the individual is working, they can also contribute their funds into the ABLE account. And then, funds from an ABLE account, like they can be used for what we call qualified disability expenses. So payments for shelter, food, anything that really will improve the quality of life of the individual. And I'm going to go back. So I said that ABLE accounts work in conjunction with special needs trusts. And if an individual is receiving supplemental security income, which is cash assistance that's supposed to be used to pay shelter, this year the amount is $957 higher per month. So in New Hampshire, it's $957, and so that cash assistance from the supplemental security income, the cash assistance from the Social Security Administration, is used to pay shelter. Now, it's 967. 967. That's used to pay someone's shelter costs. Now, I'm not sure if any of you folks can find a nice apartment or studio for that much. And so, usually what happens is if someone has a self-settled special needs trust or third-party special needs trust, the trustee can essentially transfer funds from the special needs trust to that individual's ABLE account, and it kind of washes that money clean so that the person with special needs can pay the balance of their rent. So if it's $967, And if rent is $1,000, then the $40 or $30+ extra can come from a special needs trust and move into the ABLE account to pay those funds. If the special needs trusts pay for rent directly, that's going to be considered in-kind support and maintenance to that person with disabilities, and it's going to reduce their supplemental security income by 1/3. So I'm not sure if any of you have family members that receive SSI, that supplemental security income, and you notice that the check is not $967, it's maybe like $600 and something because it's been reduced by 1/3 because they're receiving in-kind support and maintenance from you in the form of shelter. So they either live with you or you're paying some of their rent. So if you move money to that ABLE account to pay their rent, the balance of their rent from their SSI, it washes it clean. And it's not going to be considered in-kind support and maintenance to the individual with special needs. And that preserves their eligibility for getting that home cash assistance for SSI. So they work in conjunction. So you can fund the ABLE account. I see you. And please stop me. I know I got
He's excellent. It all of a sudden just went.
Oh, I'm so glad to hear that.
And last time there was a woman, if I remember correctly, who was talking about that.
Right.
That increase in payment, because they were saying she was giving inside because her son was living in an apartment on her property. So an ABLE account would have prevented that.
Right.
Okay.
The other thing you can do is if you have some relative that has set up a 5 to 9 when your child is a baby, assuming that they're going to go to college or technical school, there's a lot you could spend 5 to 9 funds on. But if that child is not going to be one of those things, you may take those funds also enable up the limit.
So ABLE accounts are like first-party self-settled special needs trusts. They have a Medicaid payback because they're considered as the funds of that individual. So upon the beneficiary's death or the account holder's death, Medicaid is going to put a lien or ask for the funds back for what they've spent or used. It's a Medicaid recovery for that individual who has an ABLE account. So it's similar to that first-party self-settled special needs trust.
And I'll jump on that. Vermont, along with some other states, has taken a public stance that they will not recover Medicaid dollars from ABLE accounts. Who knows how long that will last? It's in the federal rule that state Medicaid agencies are entitled to payback from ABLE accounts upon the beneficiary's death. But Vermont is one of the states that has said, we see that we have a right to that, but we're not going to bother because it's probably too much administrative hassle for them to do it. So they are not recovering from ABLE accounts. If they did, unlike the first party special needs trust, Medicaid can only recover Medicaid dollars paid from the date the ABLE account was established. Remember, first party special needs trust, if the beneficiary dies and there's $200,000 left in the trust and Medicaid has been paying for that individual's care since they were born, they're probably getting every dollar that's left in that trust. The ABLE account, they're only recovering up to the amount of dollars spent since the ABLE account was opened.
I would say in New Hampshire, there is a Medicaid recovery against the ABLE accounts. I have not seen them go after the funds that are paid to the account.
And a lot of folks might live in Vermont now and might move somewhere else when you die. So keep that in mind also, that a lot of other states are absolutely acting on their right to recover Medicaid dollars. Yeah.
So we have an ABLE account in Vermont. I live in Vermont. She has moved to New Hampshire. Do I switch to a New Hampshire account or stay in a Vermont account?
The question is, if the beneficiary of an ABLE account moves from state to state, do they close and reopen ABLE accounts that are in the state that they now live? Can they transport their ABLE account with them?
Yep.
Do you need to? You don't need to.
You don't need to.
I would say the matter with the recovery, the whole process.
So the question is, it doesn't matter with the recovery process. So if someone has a Vermont ABLE account and then they move to New Hampshire, Medicaid from every state you have received Medicaid benefits from has a right to recover from an ABLE account or from a special needs trust. Whether they do from an ABLE account is up to the state, but they have a right to recover from every state you have received Medicaid benefits from.
So if your daughter now lives in New Hampshire, and if she were to pass away, New Hampshire Department of Health and Human Services is going to recover against her ABLE account.
And my trust doesn't matter that I did it in Vermont.
It doesn't matter that you established your personal
The special needs trust.
It doesn't matter that you established the special needs trust in Vermont, separate entities. Special needs trusts are not ABLE accounts, that's separate.
The third-party special needs trust, remember, is not recoverable by Medicaid.
But you raise a good question, and I actually got this in an email from a client today, debating a third-party special needs trust. She said, wait, what about an ABLE account? Should I leave the inheritance for my child to their ABLE account? Generally, no. Leave it to that third-party special needs trust.
Again, because there's an annual contribution amount, even though it changes every year. If the inheritance is $50,000, the trustee can only move $19,000 into that ABLE account per year.
We have several questions online, so maybe we could go back some more. So Samuel, go ahead.
Is there ever a situation where New Hampshire Medicaid had to seek repayment for benefits upon the beneficiary staff or other family members beyond what has been contributed to the ABLE account if the beneficiary held no other assets?
No. So the Department of Health and Human Services cannot recover from family members for what's been paid on behalf of that Medicaid beneficiary. So it's usually if that Medicaid beneficiary only had $1,000, then that's what Medicaid is getting. They're not seeking recovery from other family members or people, right?
Okay, thank you.
And somebody here.
So who can then own an ABLE account? That's the disabled individual, right? Is it just 18 and over, or is it under 18 as well?
So who can own an ABLE account?
And do they have to be legally disabled SSI? Like, there's no way to work for that.
The threshold for qualifying as disabled for an ABLE account is lower than it is for that first-party special needs trust.
Okay.
To be a beneficiary of a first-party special needs trust, you have to be deemed legally disabled by a government program. For an ABLE account, you need a doctor's note.
Okay.
Saying that your disability onset was prior to the age of 26 or starting next year 46. And in general, a doctor's note suffices to qualify as a beneficiary of an ABLE account. All right, online.
Vicki, go ahead.
Hi, this is wonderful, thank you. What kind of documentation would be needed if someone I guess it might be the state or Social Security, wanted documentation out how funds from an ABLE account are being spent, determine if they qualify? I mean, does that ever happen?
Absolutely.
Yeah.
Right. No, they do in New Hampshire, they do ask to see the statements from an ABLE account. But in terms of eligibility, it's kind of like they're supposed to be turning a blind eye to that. But they are absolutely allowed to see the statements.
And keep that in mind for the special needs trusts also. Whether you're in charge of an ABLE account or in charge of a special needs trust, you have to keep very careful records. Not only is the IRS going to care about money for obvious reasons, but Medicaid and Social Security have a right to see how the money is being spent or funded, etc., to ensure that you continue to comply with all the rules. ABLE accounts are only for qualified disability expenses. They don't define what that is, and so it's like everything, but it's still limited to qualified disability expenses. And if they see that the ABLE account was spent on something other than qualified disability expenses, there's a consequence to that. And they have a right to oppose that consequence. Another email from a client today was, can I transfer my child's ABLE funds into this mutual fund? Because it's going to earn a lot more money in a mutual fund. Not if you want to preserve benefits eligibility. Money in an ABLE account is exempt. Money in that mutual fund is not. So it's not going to earn a lot of money in the ABLE account, but it's going to keep that beneficiary on their benefits. And likewise, trusts, even though they are not counted, the assets in a special needs trust are not counted against the individual when they're applying for SSI and Medicaid. Medicaid and Social Security have a right to confirm that the trust complies and that the use of the trust is appropriate. So they will ask for accountings. They have a right to see everything going into and coming out of that trust. So keep that in mind. Just because it's exempt doesn't mean you get to hide it and hide what you're doing with it for obvious reasons.
And we say qualified disability expenses. We don't really know what that is, but there, I did, in the handout, I do have a few examples of what qualifies as qualified disability expenses.
Yeah, thank you for the reminder that an audience member mentioned that their sibling had $8,000, they were $8,000 over their resource limit. This is a great use of ABLE accounts. So again, if you're going up over your monthly resource limit, what do you do with that excess money? You could establish and fund a first-party special needs trust, but since ABLE accounts were established, that is not necessary for smaller amounts of money. If you are bumping over your $2,000 resource limit every month by a little bit, a few $100s, put it into the ABLE account every month. There's a $19,000 annual contribution limit, so if you're just doing a little bit every month, you're not going to go over that limit, but you're going to be able to save that money instead of facing what people used to have to do prior to 2014 was spend down every month. I have $2,500 in my bank account at the end of this month. I need to have less than 2,000, so I need to find some way to spend 500. Again, I'm sure people could, but you can't always. They might have everything they need. How do you spend that money? You can put it right in the ABLE account.
And there's,
oh, sorry, go ahead.
And there are certain ABLE plans that have access to a prepaid debit card. So your beneficiary who has an ABLE account can actually, you can load funds onto that prepaid card and they can go to the movies with that without needing trustee discretion to give them those funds. Trustee can move funds into the ABLE account and they can get this loaded prepaid card and they can go to the movies or they can go to the supermarket. So it kind of like gives them a sense of autonomy that they can go out in the world and pay for things without having to call somebody to pay for it for them.
Vicki has a question?
Just real quick, regarding the prepaid debit card, say you get a prepaid debit card and you want to go to the movies, it's only for yourself, right? It's not for your support person or not a friend, just yourself only, right?
Support person is generally allowed from both first party and ABLE accounts. If a support person is required in order for you to go to the movies, then the funds can pay for that support person. Because that's for your sole benefit.
So we had a situation where my sister died unexpectedly. She had a disabled adult son. There were different bank accounts she set up. And a couple in his name, some in her name with him as a beneficiary. And there's also some accounts at a former bank that I haven't seen statements on recently. So my question is, would the bank know if an account is set up as an ABLE account? Is it designated at the bank? What's the designation to make something an ABLE account?
The question is, how do you know if an account is an ABLE account?
Correct.
So they're usually, what are they, state specific accounts. So Ohio has their own program called the Stable, or just Stable.
State able.
Right. And ABLE means achieving a better life experience. Your run-of-the-mill Bank of America, TD Bank, Citizens Bank, they're not going to have the ABLE accounts. So I would say reach out to attorneys. They'll know which states have the programs. New Hampshire has it, New Hampshire ABLE plan. But then I also recommend clients to do their own research because you're not limited to just using that state-specific program. So I'd say look at the programs that are maybe out of state. So Ohio, the one in Florida, and see which one fits, is a good fit for beneficiary.
And actually, Vermont's ABLE program is Ohio's ABLE program. We use Ohio's ABLE program. But you're not walking into your local bank and opening an ABLE account. It's a state-run program. You open the account through the program manager.
Okay. Thank you.
You can do that online.
Yeah, the Vermont ABLE website is pretty user-friendly for relative to state websites. It has icons, which the other state, right? Yeah, they don't always have that.
So we have a question online. I'm not sure your name. You're listed as interview team.
You're still on
mute.
Oh, sorry about that. That's me. My name's Fran. I work at Project Search, and I had a question. I had an intern who went through a benefits analysis, and we talked about ABLE accounts, and I thought that there was a something about if you work, you can actually contribute more than $19,000 a year. So could you talk a little bit about that?
Right. So I mentioned earlier the numbers, at least for the maximum, the $19,000 a year, and then the maximum that you can have for SSI, and if you're also receiving Medicaid. But additional contributions in addition to the annual $19,000, if an individual is working, they can also contribute $15,560 above the $19,000 per year in real wages. And that's for 2025, and that number may increase next year.
Thank you very much.
For the folks that aren't legally disabled that may outgrow the need for an ABLE account, I have heard there's a mechanism to transfer a balance of an ABLE account into IRA. Is that true?
The question is whether if
Not a full balance, but
beneficiary of
basically
or an owner of an ABLE account no longer needs the ABLE account, can they transfer the ABLE account funds into an IRA?
I've heard that you can, but it has to be the maximum amount that you can put into an IRA per year.
I know you come with 529s, and they're related to 529s, so I imagine that rule just changed in 2024. I'm assuming it's the same rule, so it's the IRA contribution limit, which is.
Are you asking if they can transfer the remainder of the ABLE account into the IRA to avoid the tax hit?
No, just because they no longer need it.
Okay.
So that they could convert it into an IRA, but then you'd have to do it, let's say there's the $100,000 in the ABLE account, you would have to do it over years to be able to reach the $7,000 per year limit.
I believe you can empty your ABLE account, but it's a tax deferred savings account, like the 529 college savings account.
So we would avoid that.
It's 529A, so you're going to get a tax hit if you
would avoid the tax.
Empty an ABLE account without spending it on qualified.
So that's a mechanism to avoid that tax hit. Move it to an IRA.
So are there other questions in the room?
I don't think so. At this moment.
Great. So moving on to talk more about long-term planning, right? There's a lot that goes into this. I'd like to talk about Roth IRA conversions and charitable remainder trusts. I know as the executive director of the Special Needs Support Center, when I start talking to people about leaving a legacy gift in their wills, oftentimes, this is very particular to us, people are like, well, all of our money is going to our disabled child, right? That's, it's generally leaving money to us. And so my understanding is that you could start talking about charitable remainder trusts. So could you start talking about some of these long-term planning needs for families?
So I can start just in general, more specific to the Roth IRA and kind of the next thing we're going to talk about, which is how to plan. How do you plan for your life and for the life of a child who's going to need help and live without you? The Roth IRA conversion, when you have 401k or you build up money in an IRA, at the age of 73, you're going to have to take money out, even if you don't need it. And that's at an ordinary income tax rate. So whatever your income tax rate is, that money will be in addition to that. If you're at a lower tax bracket and you can convert those funds into a Roth IRA, anything in that wrapper then grows tax-free. So the idea is if you plan it right, when your tax bracket is at a sweet spot, then there'll be more assets inside that Roth to grow tax-free. But it's just kind of one piece of the puzzle in terms of how do we make our money work as well as we can for ourselves and our individual who's going to need a lot of help. Life insurance is another thing we talk about a lot. Making sure you're maximizing your 401ks. There's little things that you can do, you know, even if you've started thinking about it 20 years later than you maybe would have wanted to. I printed out an income report. This is the report that we use with all of our financial planning clients. And if you were to come in for a financial plan, it would have income, what you want to spend in retirement, what you spend now, your life insurance, your mortgage. This one just simply was to show the power of compounding. $3,000 is a lot for a lot of people, but you can see how if you were able to put $3,000 away for 20 years, you're going to leave an individual with a nest egg, and you can, you know, extrapolate that up or down, $1,500 versus $6,000, which is in the second example. But the idea is that small changes now can make a big difference later on. And you really want to make sure that you're setting yourselves up for retirement, because if you have nothing, there's not going to be anything to pass along. So making sure that even if you're not setting up a trust that's funded when you're alive, that you're working on it and making your money work as hard as it can for you. That didn't answer the charitable remainder question.
No, but with Roths or with in that category, there was an act passed recently that actually was a benefit for disabled individuals. Right? If you are an eligible designated beneficiary and one of the categories is a disabled individual, then you benefit from a lifetime using your life expectancy when you inherit retirement plan assets, as opposed to being forced to draw on that retirement plan over what used to be 5 years and is now 10 years. So if mom and dad have retirement plan assets and they pass away and the disabled beneficiary or their special needs trust is the beneficiary of retirement plan assets, it pays out to that special needs trust based on the disabled child's, adult child, whatever, their life expectancy. So the tax hit is less. As opposed to a non-disabled individual, they don't get that benefit. They have to draw down the entire retirement plan within 10 years, which means they're probably in a higher tax bracket now because they're getting more income and they're paying taxes on, if it's not Roth, they're additionally paying taxes on that retirement plan asset. That makes sense. And charitable remainder beneficiary trusts, charitable remainder trusts. I'll speak for myself. This is not something we're doing for folks very often at all. It's essentially a trust that you set up for a charity. You could name Special Needs Support Center as the beneficiary of this charitable remainder trust. And then someone else gets the income from that trust during their lifetime with the understanding that the balance of the principal will be distributed to that charity upon death. a number of reasons to do that, a couple of reasons not to do that, and maybe why our office is not doing it that much. Your child may have a whole lot of support centers throughout their lifetime. So if you name, for example, one organization that is where your younger child is currently housed, and you want them to receive the entire balance of this charitable remainder trust, well, that entity is going to get that money even if your child has now lived in 4 different other wonderful places. There are other ways to give to charities, not just lifetime gifting, but designating a charity as remainder beneficiary of a special needs trust. Your money that you worked hard for and that you want to benefit your disabled child goes into the third-party special needs trust and is used for your disabled child or disabled family member for their lifetime. It's for them. Maybe it'll be spent down to 0 and your family member had a wonderful life as a result. If there's any money left over, then that charity can be the designated benefit, the remainder beneficiary of your special needs trust. That's typically how a special needs plan can contribute to a charity and still fully benefit the disabled individual for their entire lifetime.
And I would say that I also don't have any experience doing charitable remainder trusts, but that's what Caitlin said is how I would set up a contingent beneficiary charity to receive on the beneficiary's death as well, if there's anything left over.
And you can put conditions on that too. So this entity will receive whatever's left when the beneficiary of the trust dies, if that entity is providing services to that beneficiary when they die. You can have conditions on gifts.
I know this is asking really specifically, but I mean, if you had I get the terminology right, a remainder beneficiary off that third-party special needs trust, I don't start. Could the remainder beneficiary be somebody who is not, like a sibling who is not in need of special needs support services? Like, can the remainder, if there's anything, go anywhere, basically? So,
the question is, a third-party special needs trust has a primary beneficiary who's typically the disabled individual. When that disabled individual dies, can the remainder beneficiaries be anybody?
It could go to a sibling if the sibling is.
That's absolutely. Yep. I think we've got a question on the line.
Yeah, Julie, go ahead.
I wanted to take a step back about the act that Caitlin mentioned that was passed recently where retirement funds can be spread over the life expectancy of the beneficiary in the special needs trust. And I'm just wondering, is that a legally, someone who was legally disabled, or is this a doctor's note?
That's a good question. I don't know the answer to that. So whether how do you qualify to be an eligible designated beneficiary? How disabled do you have to be to qualify for that tax break, essentially? And I don't know the answer to that.
I know what to Google,
but I can, I can get back to you.
We can find that out.
It's the Secure Act. And there's nothing more I can tell you about the Secure Act. It is so horribly confusing, but SECURE, Secure Act.
And the exception, what are the exceptions? And then for disabled individuals, what is the definition of disabled? That's how you find it on Google.
Do you have anything about property in trusts? You know, like if you set things up really well and you own a home or property, you know, obviously there's like the crazy thing that happens if you're young and you unexpectedly die and you have the property. But if there's a way of setting up ahead of time for someone who's disabled, you know, in the future, is it better to not have the property in the trust that goes to them, or is this property okay to have?
The question is, how do you deal with real estate with special needs trusts?
Yeah.
Well, it depends. Again,
that's pretty general.
Is the person living in that property? I mean, generally, if the person's not living there, you probably want to sell the property and invest it. If the person is living there, it's going to mess with benefits.
So that's actually a very good question, because for us, we have 2 house sites on our property. And we're thinking of putting a home for our 2 boys on the lower part. So they'll be living on that property, I suspect, forever. But maybe not.
Like one might imagine, oh, I set up this property just perfectly with this house and blah, 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 blah. It's a good thing, but maybe it's not a good thing.
Part of your comprehensive estate and special needs plan, when you meet with an attorney, absolutely one of the big things that you were talking about is where is this disabled individual going to live and how. You have a house? Great. Do you have a ton of money to also put in the trust to pay for the house? Because they don't have it. They're on Medicaid and SSI.
Right.
So in general, to answer your question very generally, if you're funding a trust, any trust, with real estate, you want to, I'm sure there are calculations of recommendations, but have at least the value of the house, if not more, in cash in that trust also. Roofs are expensive, boilers are expensive, taxes are expensive, and your disabled individual is not going to be able to afford that most likely. So only put a piece of real estate in trust if there is also a ton of cash. But the conversation about I have an accessory dwelling unit on my property and my child could live there and this is the person who could live with them, that is so case specific and is absolutely a huge part of the conversation you have to have with your
Can your life insurance fund that trust? So for us, we took out large policies because we were worried about those things. We may not have that to put in now, but if something happens, the life insurance could then go in to be that fund, right?
The question is whether the life insurance can pay into the special needs trust.
Yes, and that would be a great way to handle it.
I'll tell a cautionary tale. Lovely clients had a term life insurance policy, and the term was a pretty significant age. I think it might have been like close to 90 or older than 90. They're very healthy older folks who are just shy of aging out of their term life insurance policy, which they set up to be the only funding mechanism for their special needs trust. So they had to do a lot of replanning because the plan that they had put in place is not going to be carried out because they have outlived the plan that they put in place. Also, it's caution better.
And there are riders that you could put on term insurance that would turn it into whole life. You just really need to know what you're getting into.
Yeah, they had an option like that. It was prohibitively expensive. So yeah, exactly. Do that planning. Have those conversations.
Life insurance, sooner the better, it's long better.
And I would also say, going back to the real estate and the trust, you can think of a trust as a roadmap for your trustee. So if the beneficiary is going to live in that house, you also want to talk to the attorney about what the terms are. So who can live in that house with the beneficiary? How long can that person live in the house with that beneficiary for? Is it a caregiver? Is there a caregiver agreement? So again, sitting down with your attorney and walking through the steps, because I'd say real estate trusts, when I'm drafting them, I want to be very detailed because I don't want the trustee to be like, what if this and it's not in my roadmap? What am I supposed to do now? So I want to be very clear with when I'm drafting a real estate trust. It's like a little roadmap in my head of what the questions are that I want to ask my clients are: who's living there, how long they're living there for, what the carrying costs are for the house, what the set-aside amount to pay those carrying costs are, what happens if there's waste in the house, who's paying for the waste or destruction, all kinds of things. So
it can get complicated, and I mean, that's why we're here.
Yeah, it's helpful. I think the other thing that we encourage clients to do, I think people sometimes when they go to get their estate planning done, it feels one and done, but when you open a new account, you need to make sure that's in the trust. If your circumstances change, so we're all constantly asking our clients, when's the last time you spoke to your estate attorney? Because it's important to update just like any other plan.
that's a great transition to just this broader question of how can families prepare for the financial needs of both their child and their own retirement needs?
Yeah, so I spoke about this a little bit, but I think thinking really creatively about how to maximize what you have. People's circumstances are all different, but there's life insurance, which, depending on when you buy it, is a very rather affordable way to have a large payout if you live to the right age, right? There's lots of different ways to look at that, but making sure that if you're still working, you're maximizing your 401k contributions and then potentially converting them to a Roth. If you are able to tax plan in a really efficient way, I think that the key thing that I struggle with, that my clients struggle with, is it's so daunting and it feels like you need so much money. But the reality is small, and that's why I printed that page out for everybody. Small changes can make a big difference. And not to say $3,000 a year is a lot for a lot of people, but anything that you can make work a little bit harder for you without making it, without investing in crypto or something. Any creative way that you can utilize life insurance and utilize tax planning and make sure that you are all set for your retirement. And then, you have additional assets to transfer onto your kids. I think creativity and planning is the key.
That reminded me of a question I thought of a few minutes ago. Is the way that we have short lists of helpful attorneys and helpful, other short lists, is there such a thing as a short list of helpful tax CPAs?
The question is if there's a list of CPAs that work with families with special needs, family members.
I think from a special needs planning perspective, the tax planning is probably not the least important, but the least important that they have special needs experience. The tax laws are kind of what the tax laws are. But just like every profession, there's good CPAs and less good CPAs. So I think we all kind of have lists of ones that we've worked with that we think do a really good job. But you're not going to find a certification necessarily.
And use caution when you go to the CPA or your financial advisor. The client I referenced earlier wanting to move money from an ABLE account to a mutual fund, that was at his financial advisor's direction because they want to maximize money. They want to make their client money. I want to protect my client's public benefits. So just proceed with caution.
And I'm going to suggest the reason that I asked Kate to be on this panel. She's not an attorney. She does wealth management, but kind of specializes in wealth management for families who have kids with disabilities. So I suggest her as well.
Yes, Kate is the best.
But I think building your team, like whether it's your CPA, and find the person you trust. If you started with a state or special needs attorney, find the people that they trust. Your team needs to be cohesive, and they need to talk to one another.
Another thing to do to plan ahead for your retirement future and your child's financial future, and this circles back to something I was kind of pounding at the first presentation, is maximize benefits. Even when it maybe doesn't feel appropriate or maybe doesn't feel necessary, it might actually be more appropriate to maximize those public benefits so that you can save the private resources for other things or for yourself, for your own retirement and the rest of your life, with something left over for your kids, because they have that SSI, which turned into CDB, childhood disability benefit income, when you retired. If you didn't get that SSI when your child turned 18, or if they never had SSI, they're not going to get that future income stream. So know what the benefits are that your family member might be eligible for, and do your best to maximize those, because then they're getting as many public resources as they can that you would otherwise be spending your personal money on while you're alive.
And having a plan B, and that can be super daunting too, but we were talking about it last time. A lot of these benefits are like, what's going to happen to them next year or in 5 years? That's a scary reality. But, you know, a good team can kind of lead you to several different what ifs.
Are there any questions before I have the last question? Okay. So I know that we started off actually, Allison, you started off with some common myths or misconceptions. I'm wondering if there's anything you haven't hit on yet for these common myths. Or, and again, this in the last 10 minutes is a great time for people to ask questions, you know, about something earlier that they didn't get a chance to ask.
I did mine already. I don't know if I said mine or not, but you don't need to be super wealthy to need estate planning, to need financial planning. It is important across the board.
And I guess the last session I mentioned that a misconception that I've seen with families who are doing their estate planning and have a child with special needs is that they want to benefit there over 2 children. Let's say they have 3 children, one with special needs, and they want to benefit the 2 children instead of the child with special needs because that child has public benefits. And I kind of walk them through the why they don't want to leave, and it's usually because, oh, if I leave them something, they're going to get knocked off of their benefits, and that moves into the discussion of having these third-party special needs trusts and perhaps an able account, and then their eyes are like, wow, you've opened up this whole new world to me. So I would say that that's one of the typical ones that I do get.
And I said mine too. The biggest misconception is I have a trust, so I'm done. And that goes with special needs trust too. I just want a special needs trust. I don't want to pay you for all this other estate planning. Great. But what funds the special needs trust? You've got to have that will or revocable trust that actually funds the special needs trust. Every trust is just an empty bucket, and you've got to make sure that that bucket is being filled with the assets you want to fill it with. And the document itself is a very expensive stack of papers until you do that.
Yeah. I like to say there's 2 steps to this process, right? There's getting the documents to say what you want them to say, and then there's making sure your plan functions as efficiently as possible. And that's what we're going to help with. And yeah, there's nobody better than these 2 too. So,
with everybody here, yeah.
No, I mean, yeah. We're here to help.
Any last questions? Well, thank you, all 4 of you. For everybody in the room, I have picked up the contact information for all of these panelists, and as well as the sheets that they all were showing you today. And I know those got sent out earlier to all of you online. These individual panelists will not come back to our third session as hiring these panelists for our third session. Our third session is on long-term services and supportive housing. So that will be a little bit different. I will say supportive housing, #1 question that I get at the Special Needs Support Center is help with that. So I think that we're going to have a lot to talk about there as well. Thank you all very much. Thank you.